Good morning. My name is Brett Eliasen. I'm an attorney with the Law Office of Jacob E. Martinez. I'm joined today by Tyler Selcer, another associate attorney at our firm. And today we're going to talk about an issue that doesn't often come up in the context of a criminal prosecution, but it's something that we've seen more of recently, particularly in light of current events and protesting that's been going on. That's the First Amendment. Tyler, why don't you kind of talk about what the First Amendment is and what it protects?
Yeah, the First Amendment, as many of you may know, it applies to Congress. It applies to our federal Congress, and it also applies through the 14th Amendment to the states as well. And it says that whether it's Congress or the state, they can't make laws which abridge certain freedoms. And we know among other freedoms listed in the First Amendment are the freedom of speech. We also know as the freedom to gather peacefully, to assemble peacefully, and the freedom to petition the government for redress of the grievances that you have. And these are all fundamental rights. They're in the First Amendment, and they're the cornerstone of our democracy. And they're tied to many different charges that may arise. As Brett said, some of them can be criminal charges. I just wanted to start just why does the First Amendment matter? And the First Amendment it seems like such a basic question, but it's imperative. Your ability to speak freely and to assemble, to gather, to protest, to request redress. These are all the key and historically incredibly important. So they're important to your ability to self-govern. They're important to our democracy. They're important to the truth coming out with enough voices expressing their opinion. The truth in the form of a democracy is going to prevail. So it's got an established importance, and it can be important specifically to your case. So one of the first cases that talks about speech, whether it's verbal speech or even expressive conduct that can be limited, is the Brandenburg Case, which tells us that what the court calls fighting words, or words that are likely or intended to elicit imminent lawless action and which are designed to create that imminent lawless action, those can be limited. But speech can also be limited in other ways. Brett, can you talk a little bit about the importance in 2020 right now of the ability to assemble peacefully, to protest, and to petition the government for redress of grievances?
I think here in 2020 we've seen levels of protests that probably haven't been around since the 60s. And the resulting cases and essentially charges that are coming from these protests have really brought to light these First Amendment issues. For example, when a governor or a mayor imposes a curfew, when the police designate a protest as a riot, or some other designation changing it from a peaceful protest into some kind of lawless action, allows the law enforcement then to take action against people. And what we've seen is that action has come in the form of kind of dispersing the crowds, making arrests even kind of indiscriminately. And so we can really see the strength of the First Amendment being eroded in today's society. That means we as defense lawyers have to push back.
And that pushing back, that comes in many different forms, whether that comes with negotiations with the prosecutor about, your circumstances, what led you to making some of the decisions that you made, or even your own criminal history and the fact that you may have proven that you're not the type of person to get in trouble and this may be an isolated event. Unfortunately, our office is all too familiar with people who are intending to peacefully protest, and they may find themselves in the moment, maybe get caught up in the moment and do something they didn't intend to do, or maybe they're just being charged with something they didn't do at all. They may be looking at a curfew charge, like you said. They may be looking at a disturbing the peace charge or something similar. If you're finding yourself in one of those situations, you need an attorney who's familiar with the First Amendment, is familiar with how it ties in, the protections in the First Amendment, how they tie into these charges. And you also need to know that there's other charges that can arise when you're looking at a potential charge arising out of the First Amendment. And one of the ones that comes to mind for me is hate speech. And you may not have even intended to put some hate speech out there, but it's going to be important to your case if you've been charged with it. And I'm going to let Brett talk a little bit about how that hate speech charge may play into the current charges you might have.
Yeah, the idea of hate speech or bias, essentially, has been encoded by our legislature as an aggravator. So let's say a person commits harassment. Harassment is defined as shove, strike, kick, or unwanted touching. If a person commits that crime, it's an M3, a class 3 misdemeanor. However, if it is suggested that there is a racial or ethnic or religious bias for committing that exact same crime, it escalates from a misdemeanor class 3 to a misdemeanor class 1. Similarly, if the conduct leads to harm, if a person knowingly causes harm, rather than considering what the penalty would have been under the statute, for example, assault. Simple assault is a class 1 misdemeanor, and simple assault carries the elements of a physical contact of an offensive nature that causes pain. If a person, while committing that assault, suggested a racial, ethnic, or religious bias, that would escalate that penalty up to a class 5 felony. So now we've gone from misdemeanor land up into felony territory, which of course comes with a number of consequences. And even further, if that person is in a group while that assault is committed, it's escalated even higher up to a class 4 felony. And so you can see the language, the expressions, the body language even that you make while you're committing a crime can lead to a significant escalation if it's believed that there was a racial or religious or ethnic animus behind that crime.
So if the hate crime allegation is something that you're looking at, if that's part of your charges, obviously that's going to make things a lot more complicated. And another wrinkle to kind of throw on top of that is it's not just the victim's actual race, ethnicity, or religion, it's also their perceived ethnic race or religion. So
and sexual orientation.
And sexual orientation. That's another one of those factors that's considered, and you just need to think about how it may not be their actual race, religion, sexual orientation, but just their perceived race, religion. So that is just one of the many wrinkles that needs to be ironed out when you're looking at one of these charges. Both Brett and I are both familiar with how to handle these cases, how to handle the hate crime enhancement, as it were. So we look forward to being able to talk to you about your case specifically, about your charges, and how we might be able to help you.
Thank you.
Thank you.